Welcome. Today, we're diving into the legal processes of dismissing and withdrawing charges in New Zealand. These procedures are crucial in the criminal justice system, ensuring fairness and efficiency. Let's start with the dismissal of charges under Section 147 of the Criminal Procedure Act 2011. This section replaced the former Section 347 of the Crimes Act 1961. There are key points to understand when a judge considers a Section 147 application. 1. The main question is whether there's enough evidence that, if accepted, could legally prove the case. 2. If the evidence is sufficient and a jury could reasonably convict, the application should be dismissed unless there's been an abuse of process or no useful purpose in continuing the proceedings. There are three broad grounds for dismissing charges. 1. Where a properly directed jury could not reasonably convict the defendant. 2. If continuing the proceedings serves no useful purpose, such as if only a nominal penalty would be imposed. 3. Where there has been an abuse of process. When assessing if a jury could reasonably convict, the Crown's case is taken at its highest. The evidence is considered as a whole, focusing on its cumulative effect. A judge won't dismiss charges if there's sufficient evidence that, if accepted, could prove the case. It's important to note that a family violence complainant's retraction of a statement doesn't automatically lead to a discharge under Section 147. The jury decides which statement is the truth, considering the Evidence Act 2006. An abuse of process can also lead to dismissal. The categories are broad and include 1. Police misuse of investigatory powers. 2. Prosecutorial misconduct or procedural failures. 3. Delay. 4. Proceedings creating a risk of an unfair trial. 5. Manifestly discredited or unreliable witnesses. An application for dismissal can be made before a verdict or guilty plea. While often heard in chambers, any formal order must be given in open court. Now, let's discuss the withdrawal of charges under Section 146. This often occurs as a result of a plea bargain. Key points about the withdrawal of charges. 1. The prosecutor may, with the court's leave, withdraw a charge before the trial. 2. Withdrawal isn't a bar to other proceedings in the same matter. 3. However, refiling a charge after an agreement to withdraw it may be an abuse of process. In summary, the dismissal and withdrawal of charges are vital legal processes in New Zealand. They ensure fairness and efficiency in the criminal justice system. Dismissal focuses on the sufficiency of evidence and potential abuse of process, while withdrawal often involves plea bargains.